My dear students, today I have selected a topic on criminal conspiracy under Indian Penal Code. There are two sections deals with this subject, section 120A and section 120B. Section 120A defines what is a criminal conspiracy. Section 120B provides punishment. So section 120A IPC reads the criminal conspiracies like this: where two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means, such an agreement is called criminal conspiracy. This is the definition given under section 120A, which means agreement between the two or more persons. The first point is there must be an agreement between two or more persons. For what that agreement? For what the agreement? What they are going to do? The agreement is to do illegal act. The agreement between two or more persons is to do illegal act. This is one type of conspiracy. Second, or the two or more persons are entered into agreement to do an act which is not illegal. Act which is not illegal. Act which is not illegal means legal act. So two or more persons agree to do a legal act by illegal means. This is the second type of conspiracy. So if you look into the definition of section 120A, you will find two types of conspiracies. Number one, agreement to do an illegal act, or agreement to do a legal act by illegal means. Only such agreements is called criminal conspiracy. This is the definition given under section 120A. There was a proviso also. There was a proviso under section 120A. Provided that no agreement except an agreement to commit an offense shall amount to criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement as a result of such conspiracy. This is the proviso under section 120A. Says that an agreement, except an agreement to commit an offense. Just you remove the line, except for an agreement to commit an offense. You forget about that line. Now read the rest of the verbal. So here the no agreement shall amount to criminal conspiracy unless some act besides the agreement is done by one or more of the parties. So what this provision says, mere agreement itself is not sufficient. In addition to the agreement, some overt act or some physical act is to be done by one or more of the parties to such agreement as a result of such conspiracy. So just agreement is not sufficient. The proviso says agreement is not sufficient. In addition to the agreement, some overt act or some physical act is necessary. That overt act is to be done by one or more persons. Either one person can do, or more persons can do, or all persons can do. But some overt act is to be done by one or more of the parties in addition to that agreement. Then only it will amount to the criminal conspiracy. Then what is the line which we have removed? Except an agreement to commit an offense. In such case, overt act is not necessary. Bare agreement itself is an offense. Bare agreement, where an agreement to commit an offense, bare agreement is itself is sufficient. Overt act is not necessary. In other than offenses, where an agreement to do an act other than offenses, besides agreement, overt act is necessary. Overt act. So this is we can say that this is other two types of conspiracies. One is agreement to do an illegal act, or agreement to do a legal act by illegal means. This is one type of classification. From the provision, agreement to commit an offense, agreement to commit other than offenses. This is the other type of classification. And there is an explanation. It is immaterial whether the illegal act is the ultimate object of such agreement or is merely incidental to that object. We are saying that some overt act is necessary. That overt act may be either incidental to the object of conspiracy or ultimate to the object of criminal conspiracy. It is immaterial whether it is incidental or ultimate is immaterial. Some overt act is necessary. If persons have planned to kill X, further they purchased a poison. The purchasing of the poison is an incidental to the object of conspiracy. So that is also sufficient. It is not necessary that pulling the trigger or giving the poisonous food to the bee, that is not necessary. The overt act, whether it is incidental or ultimate object, is immaterial, but we need overt act. So this is what section 120A says. 120A says, what is conspiracy? To plot or scheme together. Plot or scheme together, which means the joint participation of several persons in the plot or scheme. Plot or scheme together itself gives the meaning that several persons are there. So participation of several persons in that plot or scheme. So when the several persons are involved in the plot or scheme, means there must be the prior meeting of the minds. There must be the meeting of the minds of the persons. Without meeting of the minds of the person, they cannot participate in the scheme or the plot. So we can say that there must be association and agreement between them. There must be an association or agreement between the parties. Can be defined as conspiracy. Conspiracy is plot or scheme together and the joint participation of several persons in the plot or scheme. Prior meeting of the minds is there, or association, there must be the association and agreement. Association and agreement between the parties is required. Now, according to section 120A, we have already studied that there are two types of conspiracies. Agreement between the two or more persons to do an illegal act. One. Second, agreement to do an act which is not illegal but by illegal means. An act which is not illegal means legal act. So agreement to do a legal act or agreement to do a legal act by illegal means. Now, what is an illegal act? And first let us see what is the definition given under Indian Penal Code. Section 43 of the Indian Penal Code defines illegal act. Section 43 of the Indian Penal Code defines illegal act. So illegal act, a thing which is an offense, a thing which is an offense is illegal act. A thing which furnishes a ground for civil action. A thing which furnishes a ground for civil action is also an illegal act. A thing which is prohibited by law. All the three are illegal acts. So a thing which is an offense, a thing which furnishes a ground for civil action, a thing which is prohibited by law. So illegal act means three things are involved in it according to section 43 of the Indian Penal Code. Now how many conspiracies are there? We will get the 4 types of conspiracy. Section 120 gives only 2. If you analyze illegal act, if you see the definition of illegal act, you will get 4 types of conspiracies. That is agreement to commit an offense, agreement to commit a civil wrongs, agreement to commit a prohibited acts, agreement to commit a legal act by illegal means. Section 120 gives only 2 types of conspiracies: agreement to do an illegal act, agreement to do a legal act by illegal means. If you see the definition of illegal act again, you will get 4 types of conspiracies: agreement to commit an offense, agreement to commit a civil wrong, agreement to commit a prohibited act, or agreement to commit a legal act by illegal means. Now you again repeat the proviso. So what it says, provided that an agreement, except an agreement to commit an offense. See, 4 types of conspiracies now we got: agreement to commit an offense, agreement to commit any civil wrong, or agreement to do a prohibited act, or agreement to do a legal act by illegal means. Except agreement to commit an offense. Except an agreement to commit an offense. In the rest of the 3 cases, according to the proviso, besides the agreement, some physical act is necessary, some overt act is necessary. Agreement plus overt act is necessary. Again, I am repeating, we found 4 types of conspiracies by analyzing the definition of illegal act: agreement to commit an offense, agreement to commit a civil wrong, agreement to commit a prohibited act, or agreement to do a legal act by illegal means. Now the proviso says, except an agreement to commit an offense. In the rest of the category, mere agreement is not a criminal conspiracy. In addition to the agreement, there must be some overt act, physical act, is to be done by one or more members of the parties. Besides the agreement is done by 2 or more of the parties to such agreement as a result of conspiracy. So agreement plus overt act is necessary. And what about this offenses against the agreement to commit an offense? Overt act is not necessary. When you say that overt act is necessary for 3 things, for this there is overt act is not necessary, except there was a provision clearly mentioned that except an agreement to commit an offense. Means bare agreement itself is punishable. Bare agreement is punishable. See, agreement to commit an offense, agreement to commit a civil wrongs, agreement to commit a prohibited act, agreement to commit a legal acts by legal means. So agreement to commit an offense, and these 3 falls into agreement to commit other than offenses. So we got 2 types again, agreement to commit an offense, agreement to commit other than offenses. So according to the proviso, in case of agreement to commit an offense, bare agreement is sufficient, and they can be convicted for the criminal conspiracy. But in the agreement to commit other than offenses, that is civil wrongs, prohibited act, legal act by legal means, some overt act is necessary in addition to that agreement. Mere bare agreement itself is not sufficient. Some overt act is necessary in order to complete the offense of criminal conspiracy. What is this? A bare agreement is sufficient in case of agreement to do an offense. Suppose A, B, C entered into an agreement to kill X. A, B, C, D. 4 persons entered into an agreement to kill X. The moment they entered into an agreement, criminal conspiracy is completed. Whether they have proceeded anything or not is irrelevant. The moment they have entered into the agreement, criminal conspiracy is complete. All the 4 persons are held guilty for the offense of criminal conspiracy. Suppose if they commit murder, if they killed the X, they are also liable for the offense of murder. So they are liable for criminal conspiracy, for entering into an agreement to kill X, and for causing the death of X, murder. So 2 different offenses, criminal conspiracy and murder. So whenever there is an agreement to commit an offense, the bare agreement is sufficient to convict for the offense of criminal conspiracy. Suppose if 4 persons entered into an agreement to rob the bank, finished, criminal conspiracy is over. They are all held guilty for the offense of criminal conspiracy. They need not proceed anything. But in the rest of other than offenses, some overt act or the physical act is necessary. And this section 120A was introduced by the Criminal Law Act 1930. When Lord Macaulay was drafted in 1860, this section was not there. Conspiracy we can find only either in the abatement and some other sections under the Indian Penal Code. Abatement by conspiracy is only a species of abatement. That is not a substantive offense. And later, in 1913, criminal conspiracy was introduced in the Indian Penal Code. Now it creates a substantive offense. It is a substantive offense, just like any other offense, murder, theft, forgery, criminal conspiracy, just like any other offense, it is also a substantive offense. So that is the reason we said that once the bare agreement itself is sufficient to convict the persons for the criminal conspiracy where there is an agreement to commit an offense. We all know that for any offense under the Indian Penal Code or all over the world also, not only the India, all over the world, we required mental element. Essential elements of the crime is 3, physical act, mental element and consequence. But as long as any act rests in the intention only, it is not punishable. Because intention is not known to anybody. Suppose A, B, C, D are the family members, they had gotten angry on X, A wants to kill X, B want to kill X, C want to kill X, D also want to kill X. As long as it is in their mind, as long as it is in their intention, it is not punishable, because no one knows about it. Even A doesn't know that B had such an intention, or C doesn't know that A, B having intention to kill X, and so on. But so, the conspiracy consists not merely in the intention of the parties, not in the intention. Conspiracy does not lie in the intention, conspiracy consists not merely in the intention, but where? It is in the agreement. But in the agreement of two or more, not in the intention of two or more. Not in the intention of two or more. It is an agreement between two or more. What is the agreement? To do an illegal act or to do illegal act by illegal means. Okay. The agreement is very important. So long as such design rests in the intention of the accused. A had intention to kill X, B had an intention to kill X, C had an intention to kill, D had an intention to kill. The design is in their minds. It is not exhibited. It is not known each other. Is not indictable. Indictable means chargeable. It is not chargeable. It is not indictable. But once they have announced their intention, that is, they enter into an agreement, then it is indictable. Then it is chargeable. So what is an agreement? Agreement was an act of advancement of the intention. Mere intention is not punishable. As long as the design in the mind, it is not punishable. Once they announced their intention, entered into an agreement, then it is the criminal conspiracy. The agreement was an act in advancement of the intention. It is an advancement of the intention. Agreement is nothing but advancement of the intention. This is the brief introduction of what is the conspiracy, and when where agreement itself is punishable, when besides the agreement what act is necessary, how many types of conspiracies are there,